Want to come on up?
Good morning, Your Honor. Haley Jones on behalf of the plaintiff. I had with me Miss Daniel, who wanted to come to court one more time this year.
All right, good.
So, Judge, I'm not quite sure what happened on this one. Just to remind Your Honor, there was a DWOP hearing on October
I need
23rd.
to go ahead.
Okay, put us on the record. Sorry, Judge.
Let's go on the record on DC 236684 Titan Vanguard Midtown versus Builders Market. Counsel, make your appearances.
Haley Jones of Crawford, Wishnu and Lang, PLLC, with my colleague Grayson Daniel on behalf of the plaintiff.
Okay. And you had started discussing what had happened in the case, and I told you we'd go on the record. So why don't you kind of start over with that?
Thank you, Judge. We had a DWOP hearing. This defendant was hard to serve. I tried for 3 months in person at various addresses and ultimately ended up serving the defendant through the Secretary of State as an agent for substituted service under the Texas Org Code, because the tenant in this commercial landlord-tenant dispute has abandoned the business, abandoned the space, and stopped paying rent. So we had a DWOP hearing on October 23rd, where I told Your Honor that that's where we were on this case and that we had received the certificate from the Secretary of State and filed it, and we're awaiting the 10-day period to elapse so that we could file a motion for default judgment. We then filed that motion for default judgment on November 3rd, so less than 2 weeks after the first DWOP hearing. And then there was a second DWOP hearing on November 13th that I did not attend because we had filed the motion for default judgment. And I had corresponded some during that period with Ms. Pinson to set this motion for default judgment for a hearing, and was awaiting a response when we got the dismissal order. So I'm not sure what happened here, Judge. It may be that my motion for default judgment did not make it to Your Honor because I filed it around.
There was an issue with the default. I think that's probably why this happened. I would just say in the future, be careful about, I understand kind of what your thought process is, but until you have the default signed, it's probably best to either talk to Rhonda and say, hey, do we still need to show up, or go ahead and explain what's going on. According to the clerks, let me see if I can share screen this. Their service has not been completed in this case, which is why we didn't sign the order of default.
Okay.
And so that may be a mistake on the clerk's part. I'm not criticizing them at all on this, but
I totally understand, Your Honor.
But that's why the default wasn't signed. And I think there's a note in here that indicated maybe that we'd ask you guys to, there's a note by the administrator, hearing is needed for motion. I'm sorry. I think there's hearing is needed for request for default. It's on the 11-9. The defendant has not been served. I don't know if that's because of something you discussed with her, but that's what the administrators put down.
No, that's not something we specifically discussed. I would assume, I mean, this is an unusual case where we have an entity with a registered agent for service of process, and they have not maintained a physical presence at that registered agent for service of process. And so the Texas Business Organizations Code says where that's the case with respect to an entity that's doing business in Texas, the Secretary of State of Texas becomes an agent for substituted service.
I totally agree with you on that. And just so you know, I'm going to grant the motion to reinstate, so don't worry about that. I'm just trying to figure out, should we go ahead and sign the default judgment?
Sure.
I couldn't find, what date was the Whitney certificate filed?
That was filed. So we've sent to the Secretary of State the citation and the petition. They forwarded service to the defendant, and then we received back a certificate that we filed on November 3rd.
November 3rd. I don't see it. Is it part of the default judgment, or?
It is, Your Honor. I've got the motion for default judgment here.
Here, let me see. So you didn't file it separately then?
I did two things, Your Honor. I filed an affidavit proving up the certificate, saying what I did to serve the defendant through the Secretary of State.
Okay.
When I received the response from the Secretary of State, and then filed an affidavit. I believe it's on the docket as affidavit of Haley Jones.
Okay.
And then I also attached all of that to the motion for default judgment.
Okay, let me just look. So the Whitney certificate that you've attached here, it says that the process was returned to the office on August 24th, 2023, bearing notation, returned to sender, not deliverable as addressed, unable to forward. Is that correct?
That is correct. And under the cases that we cite in our motion, that is still effective service because the defendant entity has not maintained their agent for process in the state of Texas, and they are registered to do business here.
So I've looked at this, but not recently.
It's from, if it helps, Your Honor, and this is on page 4 in our motion for default judgment. It's the Business Organizations Code, section 5.251. And then there are cases that we've cited from both El Paso and Fort Worth that say, quote, "It is well settled that a plaintiff is only required to attempt service at the address given to the Secretary of State and need not make any attempt to serve the defendant elsewhere." So that notation back from the Secretary of State that they forwarded the process at the registered address is effective service under this line of cases.
So if you look, do you have your O'Connors with you?
I don't, Your Honor.
Okay, if you look at O'Connors, at least last time I looked at it, they've changed the format of O'Connors, which if you know anyone who does that, I don't like the new format, but you know, I guess they don't do it just for me because I think it's harder to find stuff. But let me see if I can find the thing on Whitney certificates. There's a discussion of the case law, and there's certain things that are included in the notation on Whitney that is effective service, and now I can't find it. Certain things that aren't, and this may be fine. I just want to service. Do they not call it a Whitney certificate anymore?
I don't believe they do, Your Honor. You asked me that question at the October 23rd DWOP hearing. I think it's practically the same. You still get something back from the Secretary of State's office that says they've forwarded service, but I haven't heard it called a Whitney certificate and since I started practice almost 10 years ago.
Yeah, maybe that's old, very old school then. It's here in O'Connor's though. I'll have to correct you then if it's
if you find it, I'm happy to be educated, Your Honor.
Let me see. Okay, so if you look at chapter 2I, section 5.2, it talks about service on the Secretary of State. Okay, here it is, and it's under 5.2, and it goes through the case law and the different notations, and it does say here to prove the Secretary forwarded the process, the plaintiff should secure a certificate, sometimes referred to as a Whitney certificate from the Secretary. So I'm not just making that up.
I never thought you were a judge.
Okay, all right. So what's the Secretary of State forwards the process? It's considered served, and then it goes through the different things. So defendants served when process returned with unclaimed, and it considered served when process refused. Return labeled not deliverable as addressed, unable to forward, which is what you have here. It says was prima facie evidence the plaintiff provided that was incorrect and defendant was not served. So if you look at GMR Gymnastics Sales versus Walls, 117 Southwest 3rd 57, which I think is the exact same thing that you have, not deliverable as address, unable to forward, was prima facie evidence that the address plaintiff provided to Secretary of State was incorrect, thus the defendant was not served. Have you looked at that case?
Yeah, and Your Honor, the distinction is that the address is not incorrect when the registered agent for service of process is listed with the Secretary of State, and that is the address used. I haven't read that case in a while, but I think it's distinguishable on the basis of the facts and that there was an incorrect address in that case where a defendant registers to do business in Texas. They formally set up an entity, they pay their tax, they pay their filing fee. They designate the address at which they are to receive this type of information, and that is the address to which the Secretary of State forwarded process in this case. And regarding a certificate from the Secretary of State, Your Honor, the certificate that we received is Exhibit 3B to our motion for default judgment.
Right, I'm looking at it right now. Let me see if I can share. Let's see if you guys can. Why is that not coming? How weird how they do this. You see that on the screen?
I can, Your Honor.
Okay, so it says, is this what you're talking about?
Yes.
Okay, it says return to sender not deliverable as address unable to forward. And that's, again, the exact same language out of this Fort Worth case, which is, I guess maybe I don't want to over rely on O'Connor's, but O'Connor's tends to be up to date. So I guess what I would want, I'll go ahead and reinstate the case. I would want some kind of briefing on distinguishing this case.
Okay.
Did you get the citation?
Yeah, we've got it, Your Honor.
Okay, and just take a look at that.
Sure, we can beef up our briefing on this point.
Yeah. And all right, anything else, guys?
That is it. Do you need a hard copy of the order to reinstate it?
We have it right here. Do you want a copy of it?
I don't need a copy, Your Honor.
Okay. We'll go ahead and get that signed. We'll get that signed and entered. We're going to put this on a, you may have to reserve, we'll see. But we'll put this on a 30-day DWOP.
Okay, and I'll appear for that hearing no matter where we are, because I've learned that lesson.
It's probably safer.
Thank you, Judge. I hope you all have a happy new year and a holiday.
I hope both of you do. It's good to see both of you.
And I hope you don't have to work too much harder today.
Well, this morning has been a little brutal, so.
It seems that way.
Yeah, just back to back to back. All right.
All right, well, y'all have a happy new year. Take care. Thanks.
You too. Okay, our next hearing is no, still got a few more.
So what is it?
I know, I'm a machine. Do you need a break?
I was trying to get you hit.
All right. BMO Harris Bank versus Applewhite are both sides here.
Good morning, Your Honor. Scott Helfand here with my colleague Spencer Tolson on behalf of plaintiff.
Respondent is here.
All right, you guys are set for trial on Tuesday, it looks like. Is that right?
Yes.
That's correct, Your Honor. Your Honor, as you know, we moved for an extension or a continuance of that. That's our first motion. And defendant filed a response. We filed a reply. Your Honor, if you have any questions, I'm happy to field those. I can also, do a short argument, whatever Your Honor prefers.
A short argument is fine.
Okay, thank you, Your Honor. So in this case, this is our first motion for a continuance. We need a continuance because we were unable to take the deposition of the defendant because opposing counsel refused to waive an objection to my taking that deposition before my pro hoc was filed. And in an abundance of caution, to avoid the threat of sanctions and striking of the deposition, which would warrant us having to, in addition to moving for a continuance, having to, redo the deposition, potentially in addition to paying sanctions. I discussed on the record with Mr. Clark at length the idea of rescheduling the deposition as a compromise, and noted in our discussion, and you have the transcript of that would necessitate a motion for a continuance. and to extend the discovery cutoff. Mr. Clark indicated that he would object to that, mostly to preserve his ability to object to any subsequent motions for continuance. He noted that in his experience, Your Honor generally grants those. Your Honor may remember that we had a short discussion with Your Honor during the deposition, and that's in the transcript too, in which Your Honor noted that Your Honor is generally amenable to such motions for continuance, assuming it's, not the sixth one, I think Your Honor noted. And this is again the first one. And so with all that in mind, we were surprised to see defendant's response, which basically accused us of gamesmanship, of failing to, exercise due diligence, and of failing to comply with Rule 252. None of those things are accurate. As to gamesmanship, obviously, Your Honor is familiar with the circumstances. I don't think those qualify as gamesmanship. As to due diligence, this case has been going on for a little under a year.
Yeah, this is a pretty new case. My typical practice is to continue cases on first settings. Did you guys get it ready by March 12th, do you think?
Sure, Judge, except we've got one issue here. We want the deposition taken at my office in person if they want to depose my client, not by Zoom. We object. When the gamesmanship was, I thought that was going to happen at the initial deposition, and then all of a sudden, Mr. Helfand showed up virtually by Zoom from Chicago, saying he was going to file pro hoc vc. And so I think our Supreme Court requires a unanimity if the deposition is going to be virtual. I don't know what your policy is on that, but
Is that they keep changing the rules on this? What is the current rule on this?
I thought, I wanted it virtual in another case, and the judge overruled, but I do not remember who the court was. It wasn't before you on this. And I can't cite you the current, usually they're dated or something. The Supreme Court rule, you mean post-pandemic?
Yeah, they had all those emergency orders that kept changing, and then there was dissents, and then they finally adopted a rule. Let me see if I can.
And Your Honor, while you're doing that, obviously, we would prefer to do the deposition remotely to avoid unnecessary costs and burden. My guess is that Mr. Clark is insisting on a in-person deposition to impose those unnecessary costs and burden, but also I disagree with his, assessment of what happened previously. That's simply not accurate. We had an email exchange with his office about scheduling the deposition remotely. His office agreed to that. So again, obviously we'll comply with whatever the Texas Supreme Court rules are. But I think here again, we're just, I really don't understand the lack of,
I think under rule, so I'm looking at Rule 21D, it says, or at least an article about it. So it's governed by Rule 21D, I think, and it says Rule 21D allows the court to permit or require participants to appear electronically after appropriate notice. So that's for hearings. I don't see anything about depositions. Anyway,
may I make a suggestion?
Yeah, I'm going to go ahead and continue the case to March 12th, unless the rules say specifically that if there's an objection for a deposition. I haven't heard that argument. I'm very open to remote proceedings. So if people want to appear remotely and it's allowed by the rules, this is just an advisory opinion, I will allow them to appear remotely. If the rules don't allow that because of an objection for depositions, I haven't seen that, then I won't allow it. But generally, I'm going to allow people to appear remotely for depositions, hearings, whenever it's allowed, unless specifically not allowed by the rules.
And Your Honor, thank you again for that. I just note my colleague, Mr. Tolson, just messaged me a copy of what I believe to be the current rule, which is Rule 199, Texas Rule of Civil Procedure 199B. And it doesn't mention, at least what I'm looking at, unanimity requirement. It simply requires that adequate notice be given, a reasonable prior written notice of intent to take a deposition by telephonic or other remote electronic means. So I understand this issue is not teed up in a brief before Your Honor, and that you're not ruling on it today. I appreciate Your Honor's comments. I did just want to bring that to the court's attention, given that this was just raised before Your Honor today.
Yeah, I'm reading the same rule. That's right. I was reading about for court proceedings. It says may take an oral deposition by telephonic or other remote electronic means if it gives proper notice. So, Mr. Clark, your client can be there in person if you like, in your office. That's perfectly okay. But if he wants to take it remotely, he can.
Okay.
All right. So March
Every time.
12th, Rhonda, go ahead and reset this. Did you provide an order for us on this case?
We did, Your Honor. We had proposed, I think, a 90-day continuance, just given the sort of moving parts. And I have the order in front of me. I'm not sure if it references that specific date, so the date would need to be changed. And we're happy to submit a revised proposed order if that's necessary. Whatever.
What day did you submit the proposed order?
We submitted it with our motion on the 8th. Well, 12/8.
I see it. Okay. So the reason I would suggest March 12th is that this is a non-jury case, right? Is that correct?
That is correct, Your Honor. I believe so.
Yes.
And that's one of our only non-jury weeks, and you're much more likely to actually go to trial. So I'm gonna leave that up to Mr. Clark. Would you rather do it on March 12th, or do you want to move it farther out? It's just gonna increase the chances,
No, as you know, Judge, you dubbed me the king of opposing motions for continuance.
So
I don't
you'd
know
rather
if you
get it
remember
done?
you did that. And I like to move it. I'm sorry we couldn't get rid of this case before the first of the year to help your stats.
Hey, I would like that as well.
That's what I was hoping, but looks like it's not going to go. Mr. Helfand wants to do some more discovery. I don't know if he needs any more depositions after that, but the 12th is a day that looks like it's good for me. It's I have 5 days after my birthday, Mr. Helfand, and it's not and I'm still going to be celebrating, and I'll be a year older, a little closer to retirement. So,
well, I kind of doubt you're ever going to retire, but we'll see that. Let's see.
maybe my daughter's been sworn in for 3 months. Maybe she'll just take the gauntlet, like in what is it, Bleak House, where they passed it on from father to son, the cases, and the ladies turned gray haired and all that. And so my daughter's just turned 28. So, she would be able to take it on and continue this case. If Judge.
Let's see how that all goes. All right, this is reset to March 12th. And I will tell you both sides that there's a decent chance you'll get reached, so you need to get it ready, okay?
Yes, Your Honor. And did you need us to submit a proposed revised order?
Nope, I already signed the order, and I'm going to give it to Rhonda, and she'll reset it.
Thank you so much, Your Honor.
And okay, Mr. Helfand, would you get back with me about dates that you like? And do you have my mobile number, sir, Mr. Helfand?
Yeah, I think we could probably discuss this offline.
Yeah, I understand. But I want sooner than later.
I'm happy to get back. Yes, I will get back to you about dates, and I'm sure I have whatever phone numbers are necessary.
Okay. You guys have
Okay.
a great rest of your day.
Thank you.
Happy New Year. Happy New Year, Judge.
All right.
Bye.
Okay. Let's go. We have one more, Tony, this last one. Let's go on the record on DC 226912, Grozier versus Perez. Counsel, make your appearances.
Good morning, Judge. My name is Hunt Bonneau. I represent 2 of the 3 plaintiffs, the widow, Beverly Grozier, and one of the sons, Jimmy Gasky. Christy Harrison in Ted Lyons' office represents one of the sons. It's not their motion, it's my motion, and so they're not going to be here today.
Okay. Anyone else here on this case?
Should be
You need to
some.
state your name. You need to unmute. You need to unmute.
I'm sorry, I had to unmute. Excuse me. Your Honor, this is Deborah Sahalski, and I represent Jago Public in this matter. My understanding was this was a joint motion, but we're certainly okay with Ms. Hester not being here. But I would like to say that Mr. Wolf is the lead counsel in this matter, and he is out of the country, it has been trying to join this Zoom link, and I signed in as a filler in case he couldn't get in. We had asked this to be postponed because he was going to be out of the country, but we did not get a response. So I will be carrying that burden unless he comes in.
Okay.
And Your Honor, I'm Jeff Seeberger for Defendant Weber LLC.
All right, you may proceed.
Okay, thank you, Judge. Judge, just a little bit of background that I think will help explain why the discovery that we're seeking is important. This was a construction wrongful death that occurred over by where the old Dallas Cowboy Stadium used to be. There's a highway being built there. And what happened was a dump truck, and dump trucks have blind spots, backed over the plaintiff in this case. And it's an important case because dump trucks backing over people cause more deaths than any other construction incidents. It's considered the most dangerous thing going on in a construction zone. In fact, 55 people a year on average die because these dump trucks have a blind spot. You know, they can't see right behind, so they need spotters and they need other things. So in this case, because of that, our desire was to determine and find out what preventative measures, what safety policies and procedures are in place for that known risk, the most dangerous risks on the construction site. And so we have tried to get safety policies and procedures, employee manuals, training videos, things like that I'm going to get into. And in addition to that, one of the defenses of Jago is that, you know, this particular dump truck driver was just unsafe. And so we were trying to discover what they knew about the dump truck driver, whether they knew what his history was. So that's the setup. Real quick, let me explain the parties. TxDOT awards the construction contract to Weber. Weber is the general contractor. Weber subcontracts to Jago. Jago is the party is the what we're here about today on the motion to compel. Jago lays asphalt. They spread pavement. Jago then subcontracts dump truck drivers to bring the asphalt to the scene so that they can lay it. So that's the defendants in line. And so we right now are compelling these documents from Jago because they were in control of the area, the work zone where this event happened. So Judge, I have three things three basic topics, and I don't know if you have my motion there, and I don't know the best way to go.
Yes, I have it. And I also have your proposed order.
Okay, great. All right. So I think I'll start talking and I will refer. I've got page numbers and I can kind of go down. I've got it on my screen. But there's three areas. Let me tell you the three areas and then we'll go into them. One of them is just insurance policies. And so I'm going to go through the different insurance policies that we know are there that we need them to give us to. The second thing is documents. I've got 10 requests for production that I need to talk about that are your basic safety policies and procedures and type information that I want to go through. And then there's 2 interrogatories that are asking them about their knowledge of this dump truck driver because they're saying, you know, he's just a bad dump truck driver. It's his fault. He was the one that was unsafe. So let me go through.
I may be looking at the wrong thing because let me see. It says request for reductions 1 through 10, request for reduction 14, and additional insurance documents. It doesn't say anything in interrogatories.
Okay. Are
Have
you,
y'all-
you're looking at my order?
Yeah, I believe so.
Okay,
Is that not the right
on
thing?
my order, it does. It says when it says item sought under Roman numeral number 3.
I don't
of
have,
my-
I don't
of
have
my-
any Roman numerals.
You know what I'm looking at, Judge? I'm looking at my motion, so let me look at the order. Maybe the order we didn't,
And have you guys conferred on this?
we have.
Okay.
If the interrogatories are not on the order, they are a part of my motion. And I could change up the order, Your Honor, if I'm
Wait.
looking at it now, and I do see that our interrogatories are not part of the order. That was a mistake.
Okay.
Okay, so
All right, so
let me,
let's, so go ahead and do this. Go ahead and share screen for me the requests for productions 1 through 10, so I can look at those.
okay. Thank you, Judge. All right, it says I'm,
Let me,
host needs to tell me it's okay, yeah.
let me enable that. Go ahead.
Perfect. All right, Judge, what I'm going to show you here, I'm going to go to the top of where I am. So this is plaintiff and intervener's amended motion to compel. And so, and then I can start scrolling down from that to the exhibits. And one will be, this is where those interrogatories are in the motion, but I'm going to go on down to what you've asked me to get to is these requests for production. And I'm at that, but I'll tell you that the request for production, the request 1 through 10, on this big exhibit PDF, it's actually page 10 through 12. But on the, I'm going to go past the interrogatories down to the request for production. And so I'm now on my screen at the request for production, which is Exhibit A. And on Exhibit A, we are to page 4. All right. Are you with me on that?
Yep.
Okay. So RFP number 1 is please produce the contract, the plans and specifications provided to Jago Public Company for bidding purposes. So Judge, when the general contractor says you can bid on it, you bid, and part of that is you lay out how the work that needs to be done, and that's going to include the different safety measures that you use. And so that bid that they gave to the general contractor would show what they intended to do. It would show whether or not they were planning on engaging in safety and how they were going to do that. And it's significant not only for our case against Jago, but our case against the general contractor. They state here that
So are you looking at request for production number 1?
Yes, Your Honor.
It says produce any reports and any and all data, raw data, diagrams, charts, underlying documentation, photographs, videotapes, audio tapes, film, movies, or any other intelligible documents or information or documents collected at any accident reconstruction, reenactment, or inspection of the scene or vehicles involved.
Yeah.
Your Honor, I'm not following that. That's not matching what I see for request for production number 1.
I can
Well, I guess
explain.
I'm looking at the wrong thing. Let me see.
Right. So this should be Exhibit A. There is also, Judge, in Exhibit B. Let me explain what has happened. Ted Lyons' office initially sent some discovery, and initially they had some requests for production that needed to be heard today. Those issues got resolved. So there's 2 sets. My request for production.
One second.
Okay.
So this wasn't working earlier. Now it's the camera for the, I don't know if that's what you do, the camera for my computer isn't working. This is working fine. Okay, I'm sorry. So I guess I'll just look at this.
I'm sorry, Judge. I'm sorry for the confusion there.
All right.
So number one is essentially that they would have bid for this job and we're asking for that.
What is the response?
That they've got an objection.
No, no,
And then
what's the defendant's response? Is the defendant here?
Deborah?
I'm right here. I'm sorry, Your Honor. And were you reading or were you asking me a question?
Asking you a question, what is the defendant's response?
The request for production was please produce the contract plans and specifications. And we objected that they didn't identify to which project. We thought that that was overbroad, but subject to that, we presented all of the plans and specifications. We produced all the documents. Their wording, doesn't limit in any way that they're talking about the project on which this accident occurred. And just to preserve that.
I agree. I'll sustain the objection. Number two.
Okay, Judge, make sure, just clarification. You're sustaining the objection because we don't know what project that we're asking about?
Right.
Okay. Okay.
Number two.
Yeah, number two, we can skip.
Okay.
Number three, and I'm going to scroll down. Judge, is a request for the internal traffic control plan. Judge, they've said that they don't have any documents relating to the internal traffic control plan, which is fine, but I'm asking to have that objection overruled. It's an important document that most contractors have, and we need an order or you to rule on their objection.
All right. I'm gonna go ahead and overrule this objection. You need to produce it.
Judge, just to give you context on this one, can you hear me? This is Jeff. I was able to join.
Sure.
Perez Trucking had worked for Jago off and on for over 20 years. And so this doesn't specify to this project. And so the way this is worded, it could include 20 years worth of traffic control plans. And so
it'll be limited to the overall limited to this project.
If it's limited to
Your
this
Honor, I'm
project,
sorry,
there
I
are
can't
no
hear you.
documents.
All right, let's go on to request production number 4.
Okay, Judge, number 4 is the pre-job. It's documentation.
I'm gonna overrule that objection.
Okay.
Number 5. I'm gonna overrule that limit to this project.
Your Honor, you're saying overrule and you're saying something else, and I cannot understand what you're saying.
Okay, overrule the limit to this project.
Overruled as limited to this project?
Overrule but limit to this project.
Correct.
Okay, excuse me. Thank you.
A copy. Number 6 is overruled. Number 7.
And Judge, if I could chime in on number 7, we have reports of other deaths, multiple other deaths on their project. And surely it shouldn't be too overbroad that we want to go back 8 years for people that have died on their site.
How big is this company? How many projects do they have?
Judge, this is Jeff. At any given time, they might have, I think, 7 projects going on. There were no deaths prior to this incident. There's one after this incident, but there's nothing that's in any way similar to this incident.
Okay, I'm gonna order you to produce all the objections overruled, but limited to substantially similar accidents.
Judge, real quick, in number 8, what we're getting at is in depositions in this case, some of the witnesses have talked about their first 2 days on the job. They watched videos that were giving some safety training. And so this number 8 specifically goes to these toolbox meetings, materials regarding the safe use of of the dump trucks, and it also mentions videos.
Your Honor, and may I address that? This number 8 specifically refers to information and training regarding dump trucks. And our client is telling us there is no specific training that they give, videos, handouts, slides, any type of training that they give specific to dump trucks. And that's what this request is asking for.
All right, so number 8 is overruled but limited to this project. Number 9.
Judge, same question, but it's not limited to dump trucks. It's limited to paving of asphalt. So they're a asphalt paving company. And so we want the training.
9 is overruled, limited to this project.
Number 10 is the price proposal for this project. When they send in their proposal, there's a price.
The objection is sustained.
Okay.
All right, where's number 14?
Okay, 14 is no longer an issue, Judge. That was the request for production done by Ted Lyons' office, and I think they've gotten that one resolved.
All right, insurance documents?
Yes. So the insurance documents that we have, and I'm going to go back up to our motion. I'm putting it up on my screen. We actually have them listed here.
Let me just ask, are they withholding any insurance documents? Because I'm going to require all insurance documents to be produced. So is there something being held?
Judge, we've produced all applicable insurance documents, but he's asking for workers' comp, which would cover our own employees. They're asking for documents that aren't insurance documents, like this additional insured form, waiver of subrogation form.
Any insurance documents that would cover this accident need to be produced.
And they have been, Your Honor.
You know, and that's where our dispute is. He says we have them. We said we don't. Last night about 6:30, sent us 2. They're not applicable because of the time. The time of coverage is different. So we just need the order that they should produce those.
And Judge, before the holiday, I had a discussion with Hunt and told him that the broker was out for the holiday. The broker sent us those documents yesterday. If they're not the right time period, we'll take care of that. But he'll have all the policies, Judge.
All right,
Okay.
guys. Thank you so much.
Judge, real quick, I'm sorry. One last thing, and I'm sorry. There's interrogatories, and I can narrow the interrogatories down to 2. It's interrogatory number 8 and interrogatory number 9. I have it up.
I'm sorry, which set is this now?
This is our set of interrogatories. It's on Exhibit A, and then it's on page 3 and 4 of that exhibit. And I've got that up. This is Exhibit A, page 3 and 4 of the exhibit. And these interrogatories are about what they knew about the dump truck company that they had hired. And so we just want them to identify each job where Robert Perez Trucking was hired, so that we can get an idea of what they knew about him. One of their defenses is, oh, he's just unsafe. It's his fault. Well, they've got a duty and a responsibility to hire safe dump truck companies. And so we would like to know what that is.
The objection to interrogatory 8 is overruled. What other one is there?
Number 9. And
Your Honor, clarification, please, on number 8. They've asked for each job, and my understanding is that Robert Perez has been an independent contractor for Jago Public for over 20 years. Can we have some kind of a limitation to time period or to types of accidents? I mean, this is extremely broad.
Interrogatory 8 will be limited to the last 5 years.
Thank you, Judge.
And what about to substantially similar or any other type of work? I mean, the similar work, something that is not just way off the ranch from what this incident involved?
Well, the issue, Judge, there is whether or not he's unsafe. And there's lots of things that have come into evidence where he's been unsafe. Maybe he didn't back over and kill anybody before, but he had an alarm. He had Judge's dump trucks have.
I've ruled, guys. You have a great rest of your day. I've signed the order. You should be able to pull it offline. If you can't read it, just let us know. You guys have a great rest of your day. Thank you so much.
Your Honor.
Thank you, Judge.
Jeff Seeberger for Weber. I do want to make one point about the proposed order that was submitted. The order that I have had relief being awarded against Weber, and this motion that is before you today does not seek relief against Weber. So I want to make sure that the order that you're looking at and signing does not impose any relief against Weber.
Okay, that should just be against Jago Public, is that correct?
Yes,
Yeah.
Your Honor.
All right, I've edited that. Find the order. You guys have a great rest of your day and happy holidays, okay?
Thank you,
Thank you,
Judge.
Your Honor.
Happy New Year.